For the record, this matter is before the court to review all outstanding issues, primarily the sale of real estate on West Newburgh Road. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff Ashley Sowards, and Ms. Sowards is present. In addition, Attorney James Petrangelo is present, and the defendant Adam Sowards is present personally here in court as directed by this court for possible contempt proceedings. The parties have conferred this morning with Ms. Soprano from the front of the court. The court does not, there's nothing in the court's queue yet, Ms. Soprano.
Yes, sir. Your Honor, there is going to end up being 3 different recommendations that are going to be in the queue. One is going to be a motion rec, one is going to be a de novo, and then after we complete the show cause, I will upload a show cause order for you to sign.
Okay.
They should be in your queue now. I apologize.
Yes, one is now in the queue. Noting that the home has been listed for sale, presumably that, is that correct, Mr. Petrangelo?
It is, Your Honor.
And the other parcel had been previously listed, correct?
No, the other is not listed. The other is basically mortgaged to the point there'd be nothing generated. I did provide a report from the realtor to Ms. LaPrade and Ms. Zagorski. I can briefly recap for you as to the situation.
Well, it's also noted, I'm sorry, Mr. Judge, that Mr. Sowards shall accept, it's recommended he shall accept the offer that's been received. So in other words, home has been listed, it's been added to the multi-list, and he's already received an offer, is that correct?
That is correct.
Is he inclined to accept that offer?
His realtor has another open house. He had one last weekend, and he has another one scheduled for this Sunday. The issue with this offer is it's a very low down payment with a closing by September 30th. And so he's doesn't appear as the strongest candidate to get through. It doesn't mean he won't. For that reason, the realtor said, he said at the last open house, he had 10 buyers come through, most with agents. He said the best bet for everybody to get this done, and I spoke to him, heard him over the phone too. He would recommend he be allowed to have the open house on Sunday and give Mr. Sowards until Tuesday to accept the best offer. He said, however, if this buyer is going to bolt, I'll tell him, and he can accept this at that time. So that's our situation. His report goes on to talk about all the work he did to get this in a marketable state, and that he said he's done an excellent job. And so we have a lot of interest, and it's actively being worked on. And the offer, if it goes through, will take care of everything and then some. It's just obviously if somebody comes in with 20% down or some ability, stronger ability, we know that Ms. Sowards is going to be more certain that she's going to get her money.
So this is a cash offer though, correct?
No, his offer is contingent on him being able to get a new mortgage with a 3% down payment. At least that's the way I read it. I did forward that offer as well.
When does the offer expire?
It does not, in my reading, contain an expiration date. And it was made just this week. So I don't, in my reading, I don't see a date that says it expires at a particular time. The realtor's in communication with this other realtor, says the buyer has limited resources to push this too much. I just would hate to, in real estate, what could happen, this guy doesn't get his mortgage and can't close, and then we're trying to move to somebody else. I think if the realtor, it sounds like he's describing a very active situation, a few days to accept seems reasonable and most designed to make sure Ms. Sowards gets her money. I think under this offer, it's to be closed by September 30th. I'm going to ask that the court consider, with any other requirements you have, that we put this over until after that date.
There's an open house this weekend?
Yes, June 1st.
Okay.
And I believe that shows up on one of the Zillow or other listings as well. I saw that yesterday when I was checking the sites.
Just wondering if the realtor can market this as give us your highest and best offer. Market in that, frame that, so people know that if they are interested, they need to do their offer, make their best offer on September 1st or that day.
And I told him if you give him a few days, it's going to be, Mr. Sowards is going to have to accept any offer on the table at that point. And so he's got these people, as I said, he's put in writing that he had that many people going through and interested. It does seem like work is going on here to actively try to get this quickly sold.
All right. And we were last before the court, Mr. Petrangelo, on August 7th. Is that correct?
Yes.
It took Mr. Sowards, 19 days to sign a listing agreement?
No. Apparently, and part of this letter is, for lack of a better word, there was more or less a junkyard going on the property and the outback areas and disrepairs. And frankly, the realtor said to him, if you want to sell this, you got to get this stuff out before I post any pictures. And so his letter says, the property held significant personal content, which he's been working to clear out, including large vehicles, storage trailers, business inventory. Based on the timeline, he's done an excellent job of clearing those out, removing items in the yard to prepare for photos. There was a large amount of work required to get the property market ready. He also worked through a significant list of primarily minor cosmetic repairs to the property, repairing siding, updating flooring, organizing, and cleaning. So then professional photos and drone shots were completed on Saturday, August 24th, and added to the MLS. So I think this realtor knows he's got a segment that's interested in this kind of property, and he's trying to make it as marketable as possible.
All right, thank you. Ms. Zagorski.
Yeah, Judge, first and foremost, my client doesn't have any obligation to maximize the profit to Mr. Sowards. Mr. Sowards has an obligation now that is months overdue. So he's had an offer, and we think it should be accepted. Mr. Sowards, this was a 10-acre parcel that my client quitclaimed to him pursuant to their judgment. Mr. Sowards has taken it upon himself to make this a 2.68-acre parcel. He had it resurveyed, and what he is selling is less than what my client gave him for this settlement, for which he has not paid. He's keeping the pond. He took the pond off of the property, and my client does not believe that there were significant amounts of items outdoors. She will acknowledge that there were a lot of things indoors, which the photos appear to show that he has removed. But this went on the MLS 2 days ago. 2 days ago. And he immediately got an offer, and we think it should be accepted so that my client can be paid.
All right, the court obviously has been informed that the current offer does not have an expiration as to a time frame. So the court does not see any harm to anyone to give Mr. Sowards an opportunity to conduct this open house scheduled for September 1st. It's right around the corner, and we can come back and review this. And if he's not received a better offer by then the court's inclined to order that he accept this offer when we come back. So the court's inclined to put this over for a week. Perhaps let's see if we have time for available on Wednesday of next week.
I can be available.
I'm sorry. Court is nothing available on Wednesday, perhaps on Thursday.
I have Thursday morning, I'm available.
Right. Ms. Nancy, do we have someone on Thursday morning?
I'm in mediation with Ms. LaPrade, but I can step out, I guess, for a minute.
Okay. How about Tuesday, September 3rd at 2 o'clock? Is everyone available?
I'm available.
I'll make it work.
All right. The court will, at this point in time, the court will reserve any decision on the current offer, and the court will simply adjourn this matter to September 3rd at 2 p.m. So, Mr. Pratt, if you could just revise your recommendation in that regard.
Yes, sir.
And then finally, and then perhaps the realtor, and I don't know if you have contact with the realtor, or Mr. Sowards is here, he can communicate with the realtor. She needs to market this as, give us your final and best offer, because we're going to accept an offer next week. So sometimes I know some communities, like real estate areas like Royal Oak, those realtors market the property as give us your final and best offer by a specific date. Maybe that they provide that by Monday, 5 o'clock or something, or Tuesday morning before we come back to court, the final and best offer. That's his court suggestion. I'll leave that to you, Mr. Petrangelo, and Mr. Sowards, to relay that to the realtor, that suggestion. With respect to the other issues, the court's received a de novo order that the referee recommend order be rescinded and canceled per enforcement order dated August 28th, 2024. Mr. LaPrade, that had to do with child support. Is that correct?
That is correct, Your Honor. It is it was before referee McKee. He requested to adjourn the matter or recommended to adjourn the matter to August 7th. That date has passed, so we are requesting to rescind, but we would like to proceed with the show cause.
With contempt, is that correct?
That is correct, Your Honor.
What are the current support arrearages?
Current arrears balance is $14,629.50.
Right. When was the last payment made by Mr. Sowards?
Mr. Sowards made a payment yesterday of $1,800. That payment has not dispersed yet, but that payment was made. This has been pending for quite a while. Referee McKee recommended the adjournment for the home to be listed. As we know, that has been delayed as well. There were no payments made during the month of July. Mr. Sowards did state he did have income in the month of July. He didn't have an exact dollar figure, but friend of the court is requesting we proceed with contempt. Thank
you. The $800 that was made online, is that correct?
It was made here at the window. It just takes a day to disperse, Your Honor.
Okay, what was that? What is the cash payment though, correct?
That is correct.
Right,
but that's not included in that arrears balance, Your Honor. That was an August payment.
The court's aware that an online payment can be revoked.
That's correct.
So I just verify it's a cash payment.
Yes, sir.
Mr. Petrangelo, have you an opportunity to discuss with Mr. Sowards contempt proceedings?
Yes, Your Honor. What I would tell you, first of all, is that $1,800 plus the amount he paid early in the month of another $700 meant that he made a full month's support payment this month. Of course, that's not July, that's August, but my client is very mindful of the fact he's overdue in this obligation and of Ms. Sowards and the children's needs. He very much is. He asked that the court consider in determining his ability in this situation. He had all of the expenses to get this property on the market to sell. He also, in the past few months, has had numerous debts, including, he said it's about $12,000 in taxes, I think is a new thing, or a number he threw out, including property taxes on this earlier this summer to make sure this did not go on tax sale. And so the money he's been scrambling to cover all of these things to make sure this property is available and marketed. And as one other thing, which isn't normally a factor, we had negotiated quite some time ago for, in the end, 6 children to be flown here for the month of July. And that was their first visit with Dad in 3 years. And as part of that, Mom had a list of, or some things she wanted to be sure were taken care of before they stayed in the house. So he's had a lot. He's scrambling around to put together. It doesn't delete the amount due and the need, but it also shows he's not just sitting around blowing all this off. This man is hustling, trying to get us across the finish line right now. I'd ask you to consider delaying or reserving a decision on this at this time.
Thank you. Obviously, if Mr. Sowards cannot afford the child support order, he's got to file a motion to reduce the support obligation. He just can't sit on his hands. The court would also note that the Attorney General generally gets cases in which the arrearages exceed $10,000 catch the attention of the State Attorney General, and they'll charge him with a felony charge of felony non-support. So what the court would like to do is secure a contempt finding today, but the court's inclined to reserve sentencing on that contempt. In other words, Mr. Sowards would be holding that key to jail, and if he does not address this obligation in a timely fashion, then he'll be putting himself in jail. So with that, the court's position on that, Mr. Petrangelo, does he want to present some testimony this morning from the front of the court, or is he willing to admit to contempt?
Your Honor, I believe my client would just not contest the finding at this point because of the amount, not the work he's been doing recently.
Right. Mr. Sowards, you understand that if you're found in contempt for failure to comply with an order of this court regarding child support, you could be ordered to serve up to 45 days in jail. Okay. You've discussed all these matters with Mr. Petrangelo, is that correct? And are you willing to admit to contempt this morning? The court is inclined to reserve sentencing, which means you got 45 days over your head, and you're going to hold the key to that jail. All right, raise your right hand to be sworn. Do you solemnly swear affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God? Yes, sir. Please state your name for the record. Mr. Swords, do you admit and acknowledge you're obligated to pay child support for the support and maintenance of the children born to you and Ashley Swords? Yes, sir. You admit and acknowledge that prior to yesterday's payment of $1,800, you had arrearages in excess of $14,000. You admit and acknowledge you paid nothing, not even $1 in the month of July of 2024. Mr. Petrangelo, do you have any questions, Mr. Swords?
Under these circumstances, I don't, Your Honor.
Right. Ms. Gorski, do you have any questions, Mr. Swords, regarding the contempt finding?
No, thank you, Judge.
Ms. LaPrade, do you have any questions, Mr. Swords?
No, I do not at this time, Your Honor.
Very well. Based upon the testimony of Mr. Swords, as well as a review of the records contained in the court file, the court finds Mr. Swords to be in contempt of court for failure to pay child support as ordered. The court, however, will reserve sentencing in that contempt. Actually, the court will order that he serve 45 days jail, but that 45-day sentence is reserved at this time, Mr. Swords. You have 45 days hanging over your head. So you're on a fine line to spend some time in jail. If you do not take care of this obligation, you need to look at selling some other assets and change your lifestyle, because it's got your first priority is child support once you pay these sums due to Ms. Swords. And again, there's about $180,000 some dollars due to Ms. Swords, and nothing's been paid on those obligations as of this date. Is that correct?
Judge, the amount owed for the property settlement is $108,920.59. He also owes over $14,600 in child support, and that amount does include the $1,800 he paid yesterday. Until yesterday, it was over $16,000.
The property settlement's about $108,000?
Yes.
Yes.
Okay.
There's another $80,000, but that's not due until 2027.
There's also $18,000 for the business portion, I believe.
That's included. That was supposed to be paid in March.
All right. So as of the date, it's about $108,700 some dollars due for the property settlement. Is that correct? And hopefully that can be paid out of the sale of the proceeds from the real estate.
Yes.
That will certainly assist. So, Mr. Pratt, perhaps to the rec, you can just simply add that Mr. Sowards is found in contempt. 45-day sentence is reserved at this point in time, and the matter will be adjourned.
Your Honor, front of the court would request we move this to Ms. Hicks' docket October 1st at 8 a.m. to make sure that September payment is made. That would be the request on the show cause.
Very well, so ordered.
Thank you, Your Honor.
And we'll put this back in our docket for Tuesday, September 3rd at 2 o'clock. Anything further this morning, Mrs. Zagorski or Mr. Petrangelo?
No,
No,
thank you.
Your Honor.
Right.
Is,
Right. Thank
is
you, Mr.
that
Pratt, for your assistance this morning. I'm sorry. Go ahead.
your, October 3rd is a Thursday. Is it?
October 1 is the show
October.
cause. September 3rd is to monitor the open house, Mr. Petrangelo,
Okay.
just to clarify those dates.
October 1 at 2 o'clock is the show cause docket.
October 1 at 8 a.m. And then Judge said September 3rd was 2 o'clock or 3 o'clock, Your Honor?
2 o'clock.
Thank you. Let me get that corrected for you. I thought I heard 3.
Okay, and all these things, I'm sorry, confusion. The October 1 is at, you say,
8 a.m. with Miss Hicks.
A.M. Hicks. Okay, thank you.
Thank you.
And obviously, if Mr. Swords has made appearance between now and then, Ms. Hicks will not bring him before the court. If he's paid nothing, Ms. Hicks will probably bring him before the court later that morning, Mr. Petrangelo, for us in
Understood.
jail.
Understood.
Okay, all right, that will conclude this hearing. We can zoom out. Mr. Swords, you're all set to go. Talk with the realtor and have the realtor make it clear to potential buyers that submit their final and best offers by Sunday or Monday, so that they know that you are a very interested seller. All right, that will conclude this. Right now, we can zoom out.
Thank you,
Thanks.
Your
All
Honor.
right, thank you, Your Honor.
Remember, this was the one where he was sending gift cards, and he's like withdrawing. He met someone online, and then there's a fraud. They were saying, we'll release her if you send us $10,000. He was withdrawing rights from 401k. And now there's a question whether or not he was even competent, but especially when they start asking for gift cards, it's a scam.
I know, because we were trying to think, I forgot about that part. We have
Yeah.
so many new. Yes.
So they wouldn't, we stopped any access to any of his access to any bank accounts because he was, yeah.
Well, he got that $120,000.
So he didn't shut the clock on that one.
Versus Adam Sowards.
For the record, this matter is before the court for the purpose of reviewing the anticipated sale of a parcel of real estate. And the matter was adjourned from last week. This hearing is being conducted via Zoom. President is Attorney Maria Zagorski, representing the plaintiff Ashley Sowards, and Ms. Swords is present. In addition, Attorney James Petrangelo is present, representing the defendant Adam Swords. Mr. Swords is also present. Good afternoon, everyone.
Afternoon, Your Honor.
Court has received the fine recommendation from Mr. Pratt. The court is pleased to note that an offer to purchase the property and sell the property in question has been accepted, and the buyer has until September 30th, 2024, in which to close. It's further noted that Ms. Swords will receive $108,920.59, which will pay in full the property sale amounts due to her through today. All other matters are reserved for mediation with Mr. Godfrey. Further, Mr. Swords will receive a $400 credit for agreeing to pay Ms. Swords one half of the mediation fees. Mr. Gorski, is this recommendation agreeable with your client this afternoon?
It is, Your Honor. Thank you.
Thank you. Mr. Petrangelo.
Yes, Your Honor.
Okay, and you've got a copy of the accepted offer, Ms. Zagorski?
Yes.
Okay.
It was forwarded to Mr. Petrangelo. He sent it to me and I've shared it with my client now.
Are there contingencies?
It's the offer that he received last week. It's the one that requires the buyer to get a mortgage. So hopefully that all moves forward. It's expected to close by the end of the month.
Okay. What else needs to be mediated with Mr. Godfrey?
It was originally scheduled for September 23rd to talk about Mr. Sowards' holiday parenting time. We've agreed that we're also going to address my request for attorney fees for this underlying property issue and future amounts owed. And then we're back before you on Ms. Hicks' docket for the child support show cause on October 1st.
Your mediation with Godfrey is September 23rd?
Yes.
Okay. Well, you can always zoom in here if in fact you want to put something on the record on the 23rd.
Thank you, Judge.
Thank you.
So it won't be in our calendar. What time's your mediation with Godfrey on that date?
We
10
start
a.m.
at 10 o'clock,
I'm sorry?
10 a.m. because of my
10 a.m.
client's time difference. Yes. So we're starting a little bit
gotcha.
late.
All right. Well, we can pull the file and have it up here that day, September 23rd. All right. Mr. Gorski, Mr. Chandra, either way, you want your client sworn so you can voir dire them regarding this recommendation this afternoon?
I don't need to, thank you.
You're fine as well, Mr. Central? Okay. Very well. Court will adopt the agreement to reach by the parties and enter the order presented by Ms. LaPrade. And let's keep our fingers crossed that transaction closes.
Yes.
All right. All right. That will conclude this hearing. Now we can zoom out. Have the rest of the day.
Thank you,
Thank
Judge.
you, Your Honor.
Thank you.
For the record, this matter is before the court on the objections filed by the defendant, Douglas Leach, to a recommended order of judgment affiliation. This hearing is being conducted via Zoom. Is Douglas Leach present on audio?
Sir.
I'm sorry?
Sir.
Okay. All right. Good morning. Is Echo Bruck present on audio?
Yes, Your Honor.
All right. Good morning.
Good morning.
Mr. Leach, you are objecting to this judgment affiliation because, what is your objection? Again, it was not clear to the court. When you look at your document, it just simply says, I'm objecting to the referee's recommendation. Echo was very abusive emotionally and physically. You'll need to mail her a copy because I don't have her information. What is your objection to this recommendation?
My objection, sir, is that I have not seen my daughter. She's been in the custody of Echo this entire time. I've had one letter which said that there was going to be 75 days, and I know that that's just a placeholder number. But my objection is that.
So the issue is parenting time. Is that correct?
Yes, sir.
All right. Ms. Brower, for the further questions, met with the parties. Ms. Brower, what's the status of the court notes that the issue of parenting time was referred to the front court for formal investigation recommendation? Is that commenced?
It has not started, Your Honor, because Mr. Leach objected to
All right.
the recommendation referring it.
Yeah, thank you. So Mr. Leach, when you file this objection, it sort of stopped the progress, the process of having the front of the court investigate parenting time. So this child is 2.5 years old. Have you seen this child at all since the child was born?
I was there on the day she was born, and I signed the affidavit for parentage, and I signed the birth certificate, which was destroyed on the behest of the mother. I was
Mr. Leach, hold on, Mr. Leach. The question is, have you seen this child since the child was born 2.5 years ago?
She was 6 months old when I had to get a eviction notice for Echo.
Okay, I'm not asking about eviction notices and this. Have you had any parenting time since the child was born?
Yes, sir. Yeah, I changed diapers multiple times a day.
Okay, and when's the last time you saw the child?
January 2023.
Okay, so a year and a half ago. The court would like to have you talk with Ms. Barr about a temporary parenting time arrangement, and we can still have the front of the court investigate it and recommend it. Obviously, it's been a period of time. Ms. Brower, should we get him on the list for family counseling shelter services? This 2.5-year-old child, if he has not seen the child in 2.5 years. And of course, Mr. Leach, you could have taken action to file a complaint for paternity years ago. I mean, 2 years ago, if you weren't seeing the child, you could have enforced your own rights and filed a petition with the court. You've not done that. It's taken the front of the court to act on behalf of the mother. Hold on, Mr. Leach, you're talking over the court. Let me just finish. So if you had no contact with the child for the past year and a half since January 2023, we should start slowly. Ms. Barr, do you think at least get him on the list for family counseling shelter services?
It can, Your Honor, there is a distance. Mr. Leach lives in Lake County.
Oh, well, that's where's that, up near Baldwin, Mr. Leach?
Yeah, just north of Baldwin, sir. But she was born in Lake County, and I filed in Lake County. And Miss Brooke moved the daughter down to Monroe. So I filed in February 2023 to be able to, have parenting time. And so I have been on this. I've been talking to prosecutors and investigators for over a year and a half.
I was not aware there's something filed in Lake County. Is there an order out of Lake County for parenting time?
Oh, sir, Miss Brooke lost her benefits and then moved down to Monroe and refiled against me. So.
Okay, but what happened with the action in Lake County? Is it still pending?
I think it was transferred over, sir. I mean, I haven't been in contact with them since it's been moved.
No, I mean, nothing was transferred unless they closed it out. In front of the court filed something here on January 31st on behalf of Echo Bruck. Ms. Bruck was receiving public assistance.
They were telling her to the court by removing her public assistance, yes. So
obviously, parenting time is difficult when you live 4 hours apart.
Nova was born in Cadillac. This is her home. And Ms. Brooke decided to move her down hundreds of miles away. And so, yes, we have to deal with that. That's a lot of money to drive down there for sure.
But Mr. Leach could have been more active in taking action when the child was born up in Lake County. Could have gotten an order that Lake County has jurisdiction and enforce it. But obviously, it's harder when things sit for 2.5 years.
It's harder when one of the parties moves their address and then changes their phone number and doesn't comply with the court as well. And I want to make that point. I mean, parent to everybody. So.
Okay. Well, you could have been taking the initiative, filed a petition for parenting time, and filed a complaint for paternity, 2 years ago, shortly after the child was born. But you didn't do that, Mr. Leach. So I don't know what to tell you. We have no information about an action in Lake County. But your objection seemed to be more parenting time. Is that correct?
That's exactly correct, sir. And I was told that the 75 days was a placeholder, and I understand that. But I honestly was very much abused by this woman, and to leave her in the hands of this woman is not my first option. Okay. So I thought this was my best way to be proactive and compel the court to understand my point of view.
Okay, so once again, parenting time is the main issue. You just wanted to have parenting time with this child. If you think the child's in danger, you should contact law enforcement or protective services. But again, from your standpoint, the primary issue is parenting time. Is that correct?
My point here was parenting time, yeah, because if she's in my control, then she wouldn't be in danger. But I've told the Lake County Sheriff here, and they did not pursue charges.
Okay, so Mr. Leach, the recommended order says that the issue of parenting time is referred to the front of the court for a formal investigation recommendation. So let's start that process. When you file this objection, stop that process. So the court's inclined to adopt the recommendation, get that process moving again. The front of the court will make sure they have your current address. They'll reach out to you, they'll provide you questions. They're going to do a phone interview with both parties, and then they'll make a written recommendation. You both have an opportunity to file an objection to that recommendation. Come back before the court. That's the process. Do you understand that?
Sure.
Ms. Barr, do you have Mr. Leach's current mailing address up in Baldwin?
I believe we do, Your Honor.
Right. A confidential address, so presumably he got notice of this, so his address is fine. Ms. Bruck, do you have any other questions?
No, I don't.
All right. Obviously, Mr. Leach has a right to see this child. It's his child. You both that was determined by paternity testing. Is that correct? You both agree that Mr. Leach is in fact the biological father of this child, Nova. Is that correct, Ms. Bruck? Ms. Bruck?
Yep.
All right. So at this point in time, the court will adopt the referee recommended order. And the mom has sole physical custody, and the issue of parenting time is referred to the front of the court for formal investigation recommendation. Let's get that process moving. So we come back and hopefully establish some contact between the dad and his daughter. All right. Any other questions, Ms. Brock?
There was never any doubt that this little girl is mine. And I'm sorry that I'm frustrated, but it's taken so long to see my girl, and I worry about her every day. And so I appreciate your time today. I didn't want to waste it, and I know you're important and all that. So.
Okay, but let's unfortunately find the objection sort of delayed the process, Mr. Leach. So let's get it going back. The court's going to adopt the referee recommended order so that the issue of parenting time can be referred to the front of the court for formal investigation and recommendation. We'll get that going. You'll hear from the front of the court shortly. They issue, again, a written recommendation regarding parenting time. And obviously, you should put another plan, Mr. Leach. I'm not sure what your plan is. I don't know if you have family in Monroe County that can come down to visit on weekends to see your daughter. But the reality is, it's more difficult for you because the matter is now in Monroe County. You should have filed something up in Lake County. But it's now in Monroe County, and that's what we're dealing with.
I understand that. Yeah, it's a horrible thing to do. Oh.
Right. Do you have any other questions, Mr. Leach?
I want to file the de novo case against the file for child support in regards to the distance that it takes to get to. So I make very close to minimum wage, and I'm ordered to pay $175 a month, which is approximately 1/4 of the money I make for working. And so should I file the de novo case? Am I going to just gum up the process and waste your time again if I do that?
I'm not sure. You may want to talk with somebody from an attorney or legal services. Has there been a child support recommendation issued yet?
Yes.
I don't see one in the court file.
On the 13th.
So obviously, if you disagree with that, it looks like, there's actually something scheduled for referee McKee August 13th. That was a couple weeks ago. What happened with that, Ms. Brower?
Your Honor, the referee did make a recommendation on that. I believe Mr. Leach wants to object to the amount of that support.
Okay. Does he still have time in which to object?
I was just planning on doing that after this meeting today.
All right. Yeah. So yeah, if you still have time, Mr. Leach, I don't see the recommendation court file. The other thing is you can always, if in fact it's too late to file the objection, file your objection and we'll review it.
Okay. Thank you, sir.
And then talk to an attorney or someone from legal service if you can't afford an attorney.
A couple $1,000, I might do that. But.
All right. Okay, so at this point in time, the court will adopt the referee recommended order. And that will conclude this hearing. You can both zoom out. Have a good rest of the day.
Go stay on because you have your other hearing with us.
Okay.
Right, okay, you both, you can zoom out, Mr. Leach. Thank you, Ms. Bauer.
You're welcome, Your Honor.
Have a good day, sir.
Thank you. These attorneys don't look at their pleadings. Russ Smith files a complaint for custody, DC, but he already has his complaint and it's got DM at the bottom. So the clerk doesn't catch that. So, I mean, we need an order amending the caption. It's a DC case, not a DM. But he, you know, what happens is he prepares that and the clerk's writes in the middle of the number.
Yeah, because, that's what we have in the document.
No,
Because that's what she saw.
They need to pay attention to these things.
So the DC, okay.
Yeah, it's a DC case. Yeah, right away, his motion is, the parties were never married. And I'm thinking, okay, it's a DM case.
Let the DC change on your document.
Well, he's gonna need to do an order, change.
For her, so she knows what DC.
change the caption. Oh, but yeah, Stephanie should note that too. Rec. This next one's a 10-year-old. Probably just wait forever to get an order. In this case, but they're never married. No. Yeah. Yeah, so because of the fact that that's what happened. You see what I mean? When he filed this, you know, and the pleading just said 24-blank-DM. We put DC. Of course, yeah. You know, I guess Seth, I don't know who opened it. I mean, you got obviously a lot of these things going. And I suppose somebody from the court's office could have caught it, but I mean, obviously they got volume of stuff. Yeah. Let's complain for custody. Did she open the files in? Okay. Yeah, I'm not sure. I mean, the attorney should have had the responsibility to look at his pleadings. So yeah, we need to clean that up. Good morning, Mr. Smith.
Good morning, Judge.
It's here, you can hear.
Judge, I should let you know that my client is in an area where the power is out. His feed has gone in and out several times during our meeting with the friend of the court. So just so you're aware of that.
Well, Mr. Petrangelo is also involved on behalf of Echo Bruck. Is that correct?
Not to my knowledge.
The recommendation the court has references a Petrangelo.
Sorry,
No.
Your Honor. I probably just did not get that out of there when I
Okay,
uploaded it.
all right. And
I
also
apologize.
this, Ms. LaPrade, Mr. Smith, this is a DC case.
It is,
Mr. Smith,
Judge.
when your office prepares this, it's got 2024, a blank, then DM, but it's complaint for custody. You didn't catch it, the clerk didn't catch it. So we need an order modifying or correcting the caption. So if you can prepare that, Mr. Smith and Ms.
I would be
LaPrade,
happy
don't know if
to,
you
Your
want to do
Honor.
on this. Do you want to put?
It's in the recommendation on the bottom, Your Honor. I will fix the Mr. Petrangelo, but yes, we did note that this should be a DC matter as these parties were never married.
So you'll prepare an order correcting the caption, Mr. Smith?
Yes, Judge.
I'm sorry?
Yes, Your Honor.
Thank you. Thank you. I'm sorry, just an area. Very well. Again, this matter is before the court on the plaintiff's motion for joint legal custody and specific parenting time. This hearing is being conducted via Zoom. President Attorney Russell Smith representing the plaintiff petitioner, Steve. Oh, I'm sorry. We didn't call the case. Sorry. I'm sorry. I got ahead of myself. Just wanted to point out this is a DC case, not a DM case. Parties were never married. In any event, the matters before the court on the plaintiff. The plaintiff fathers a motion for joint legal custody and specific parenting time. The plaintiff being represented by Attorney Russell Smith, who's present with Mr. Lamming. Is Echo Bruck present on audio?
Yes, Your Honor.
Right, Ms. Bruck is present on audio. The parties have conferred the front of the court. The front of the court is recommending the parties shall show joint legal custody of the 10-year-old child, McKenna. And father should have specific parenting time as follows: Sundays from noon until 7 p.m. Issue of child support shall be referred to the front of the court for a formal investigation recommendation, with each party having 21 days in which to object to any recommendation. Also, it's noted that the case suffix should be DC as the parties were never married. The effective date of any child support will be August 1st, 2024. The parties will appear back before the court to review father's parenting time October 15th, 2024 at 9 a.m. That is a recommendation. Mr. Smith, does this recommendation agree with your client?
I don't think so, Judge. He believes they lived together for 11 months until separating recently. Since the separation, he's been denied any time with the child whatsoever. He's a hardworking gentleman. Certainly joint custody is a step forward. Minimally, Judge, for the time being, we would recommend every other weekend and every other holiday with a review on October 15th to potentially expand his parenting time. The mother indicated she wanted the father to spend time with the child. He wants to spend time with the child. He wants to be a dad. And like I say, they lived in the same home until recently. So that's our request today. Ideally, he'd like 50-50 time sharing, Judge, but I do not believe the court would order that today. So that would be our request.
Thank you, Mr. Smith. When did Mr. Lamming last have contact with the child?
Steve, do you recall your last contact with the minor child?
February 14th.
February 14th. He has attempted to arrange parenting time with the mother to no avail during that period of time.
Well, it's been 6 months, no contact. And at that time, back in February, what were their practice of the parties? Did Mr. Lamming regular exercise parenting time? Or did the
They
parties
live together. They live
Right.
together, Judge.
All right. All right, so Mr. Lamming is requesting overnights. Is that correct?
Yes.
All right. And does he have a bed for the child?
Yes.
Has the child ever spent overnights in his home before?
They live together.
Okay.
Three of them
you
lived
may-
together for 11 months, Judge, in the home that Mr. Lamming owns.
Gotcha. All right. That was I guess, the question in whose home is Mr. Lamming's home. So
Yes.
the minor child, McKenna, is familiar with that home and environment, correct?
I'm sorry, Judge.
The minor child is familiar with that home and environment.
Oh, absolutely.
All right. Ms. Bruck, what's your objection to dad having alternating weekends, like Friday till Sunday?
Well, because, Your Honor, I mean, it has been a while since they saw each other. Well, he did not attempt to because there was a pending domestic, which is still ongoing. I talked to Isaac Skaggs, and I've been in contact with him about the case. And, my daughter, she doesn't, necessarily want to. I've begged Mr. Lamming his whole life, her whole time being born to be a father. And he always had something better to do. Wouldn't watch her when I went to work. It was always an issue. And my daughter, she started to see that. Of course, I've always wanted her to have a father. I really, who wouldn't want one? So, she still has to brush her teeth, brush her hair. And, she's never stayed there, by herself with him. Yeah, we were there for, the 11 months or however long it was. Before that, we were up north for 3 years prior, and there was, very minimal contact. He went and took her to a water park one time in that time. He wasn't trying to call regularly, wasn't trying to, see her. So I think, to ease it into it, the Sunday would be fine. And if Mr. Lamming and I can come to agreement, okay, you want to pick her up this time, that's fine, type thing. But I'm not trying to rush my daughter into, something that she's not necessarily comfortable with.
Right. Well, she's a
so I
minor,
think
so
the
it's
Sunday-
not her decision.
Right.
She's a minor child. What about there's a pending domestic violence charge?
No, Judge.
Yep.
There was-
Back in.
I'm sorry. Go ahead.
I'm sorry. I don't know. Okay. Back in February, on the 14th, Mr. Lamming was drunk and he, came home and he was, really angry. Started trying to make himself something to eat and shoved me to the ground, kicked me in my face. And, the cops came, he was pointing guns, racking his gun, saying someone's going to die. McKenna was sleeping.
Miss Bruck, was Mr. Lamming arrested?
Yes, he was.
Was he charged with domestic violence?
Yes, he was.
Did this occur in the presence of the child?
I'm sorry?
Did this occur in the presence of the child?
No, she was sleeping.
All right. Well, was she awakened by the commotion?
She was. We had to get escorted out of there early morning, late night. And they put us in, and took us to a hotel to stay in. And then, so I have been in contact with Isaac Skaggs, and the case is still ongoing.
All right, so your daughter did not witness the alleged assault, but she was home and she heard the commotion and was taken from the home that night, correct?
Yep, me and both my daughters, yep.
All right, Mr. Smith, what about this alleged pending domestic violence charge?
Judge, the case was filed as a domestic violence charge. Case was dismissed by Judge Eicher on May 14th, 2024. And of course, what happened that night, there's two sides to every story. I won't bore you with Mr. Lamming's version, but it's drastically different than Ms. Bruck.
Why was it dismissed? Do you have any knowledge, Mr. Smith?
Yes, in the interest of justice, Your Honor.
Your Honor, if I may.
Yes, please.
There is an unarraigned warrant in the district court, case number 243009.
For domestic violence?
Domestic, Your Honor.
Mr. Smith, apparently it was dismissed, but then reauthorized. It sounds like it.
Well, it's nice of them to let me know, Judge. I had no knowledge of that. I did represent Mr. Lamming on the prior one, but certainly he was not notified in any manner that this case was reauthorized, nor was I. So we'll have to take care of that, Judge. You know, that is a matter that will be resolved in the district courts. But the fact of the matter is Mr. Lamming has no problem getting along with his child whatsoever and never has. So I would urge the court to allow the parenting time to be ordered. Parties can work out their differences through the other matter. Sorry, Judge, or Ms. LaPrade, what was the case number on that?
243009. There is an unarraigned warrant in that district court file.
Mr. Smith, has your client had any phone contact with the child since
I don't think
February?
he's been allowed to, Judge. He's made frequent requests. Ms. Bruck has blocked him every way possible, won't allow him to talk to his child. And he has made every attempt. She wants him to be the dad, and yet she won't allow him even phone contact with the child, which is, ridiculous because Mr. Lamming's a hardworking gentleman. He wants to be the dad. She wants him to be the dad. So, I don't understand that. It's mixed signals, certainly, but he is the dad. He wants to spend time with his child. I think that's honorable. There's so many dads just disappear into the woodwork. He's not one of them. So.
Have the parties discussed transportation? And again, if there's a district court bond condition for no contact, how are they going to do the pickup and drop off? So will there be a third party?
Judge, this is all new to me. Like I say, normally when there's a misdemeanor warrant issued, they send a postcard to the defendant letting him know that it's issued. He hasn't received anything, and there is no bond condition at this point. If the court orders parenting time, we would get, exception to the no contact order for exchange of the children. That's the way it normally works on those. But certainly if they wanted to meet somewhere in a safe location, my client would be willing to do that.
Have you discussed that this morning, where they're going to meet for the exchange?
No, okay. Until we were on the record, I wasn't aware of the fact that this had been reauthorized. So that never came up.
Well, regardless of that charge, Mr. Smith, what's your client's suggestion? That will he pick up and then mother will pick up from his home, or?
I don't know, Mr. Lamming. You have a preference as to the exchange?
I'll do whatever I got to do. I just want to see my daughter.
Do you want to pick up the child at her house? And then
I'm good with that if she is. One of us pick up, one of us drop off. That's fine.
Again, where do the parties reside? They both reside in Monroe County?
Yes.
We both live in Monroe.
Okay. What about meeting at the sheriff's office?
That's fine.
So a neutral location, is that inconvenient for the parties?
Probably be farther to have to go to, that part of Monroe instead of just going, straight through or, whatever. I'm not, necessarily worried, about it. It's just,
Right. Okay, so what about if Mr. Lamming picks up at noon and Mom, you pick up from his home at 7 o'clock? Does that work?
yeah. And if we have any other, things to add, I mean, that would be fine to just, whatever, as long as, I don't know. But yeah, that would work. If it's fine on his side, I don't know.
All right, the courts will modify the recommendation of Mr. Pratt. Because it's been 6 months, no contact between the dad and the daughter, the court his parenting time will begin on Sundays from noon until 7. That will begin on September 1st. So this Sunday, Mr. Lamming, you'll pick up your daughter from Mom's home. I assume you know her home at noon to 7. And the court wants a couple of weeks of just Sunday parenting time, and then we can change it to alternate weekends. So Mr. Lamming will have Sunday, September 1st, 8th, and 15th, just the Sundays. And then he'll have a weekend beginning Friday, September 27th at 4 o'clock until Sunday, September 27th at 7 p.m. That weekend, as well as the weekend of October 11th to come back. So there'll be some overnights in the interim. We'll see how McKenna adjusts. Mr. Lamming, you got to make it comfortable for her so that there's not any problems. So again, Dad's parenting time will be on Sundays from noon to 7 for Sunday, September 1st, 8th, 15th, and the 22nd. And then overnights, alternate weekends beginning September 27th, 2024 at 4 p.m. until Sunday, September 29th at 7 p.m., as well as the weekend of October 11th through the 13th. Were you able to follow that, Ms. LaPrade?
Yes, Your Honor.
The court noting that this is a 10-year-old child, it's not a 3 or 4-year-old child. The child's lived in Dad's home for a period of time, notwithstanding the fact there's been a period of separation. Again, the issue of child support shall be referred to the front of the court with effect date of August 1st. The court will review parenting time October 15th at 9 a.m. Hopefully things will go well between now and then. Ms. Bruck, do you have any questions?
Yeah, so starting, you said September 27th, would that be a Friday?
Correct. September 27th is a Friday at 4 p.m. Dad will pick up.
Okay, because she gets off the bus a little later than 4.
Okay.
So
what time do you suggest? 4:30? Or do you want Dad to pick up from school?
Either, well, he works on Friday, and he works afternoons.
Okay.
So I don't know who he would have pick her up, and he wouldn't even be spending any time because he'd be at work till 10.
All right. I was not aware of that. Mr. Smith, your client works afternoons on Fridays?
Steve, are you hearing this?
Yes.
I'm
hearing it. I work afternoons, yes. My job has what's called Blue Line, so I could be out of there anytime from 7 o'clock to 10 o'clock at night, but I'm sure I can arrange somebody to pick up my daughter and take care of her till I get home. It would be family, so she would just be...
This is parenting time for you, Dad. What time do you get home on Fridays?
It's not guaranteed to be home until 10:30 at night.
All right. Dad's parenting time will be
4 or 5 days a week. I am out of work early.
What time do you want to pick up on Saturday morning then?
I'm sorry, I still didn't hear you.
What time can you pick her up on Saturday?
9 a.m., I guess. I don't know.
So Dad's apparently the overnights shall be on Saturdays rather than Fridays because he's working, not at home. He's got to be there. Then he'll pick up on Saturday morning, September 28th, and keep her overnight till 7 o'clock, September 29th. And then alternate weekends after until we come back to court. So it'll just be Saturdays and then overnight Saturdays until Sunday evening. Any other questions,
Judge.
Ms. Brock?
Yes,
I'm sorry?
I didn't hear you.
Do you have any other questions?
I do not.
All right, Mr. Smith, anything further?
No, Your Honor. Thank you for your time today.
So you're welcome. And Mr. Lemmy will then have the parenting time this Sunday, which is September 1st. Again, to noon till 7. And then his overnights will begin on Saturday, September 28th in the morning.
And Your Honor, who is doing the transportation so I can make sure that order is clear?
Father will pick up at the beginning of parenting time, and mother will pick up at the end of parenting time.
Yes,
The
sir.
parent who's entitled to the child shall pick up at the other's home. And Mr. Smith, you'll prepare an order amending the caption of the case.
Yes, Your Honor. I'll send that right up, and I do apologize.
Thank you. Thank you. Any other questions, Mr. Pratt?
No, sir.
All right. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, Judge. Have
Welcome.
a good Labor Day if I don't.
For the record, this matter is before the court for the purpose of reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Russell Smith representing the plaintiff father, Stephen Lamming. Mr. Lamming is present. In addition, Echo Brooke, are you present on audio?
Yes, Your Honor.
Good morning. Parties have conferred this morning with Ms. Brower from the front of the court as it was provided the court to find recommendation. That the party secretary to share joint legal custody of the minor child, McKenna. The physical custody is reserved. And Mr. Smith, Mr. Lamming, Ms. Brock, the court is of opinion that people make too much of an issue over physical custody. With joint legal custody, the two of you should share equally any major decision concerning the welfare of your child. So it's just a matter of parenting time. And the recommendation relative to parenting time is as follows. That father's parenting time shall be the first, second, fourth weekends of each month. Saturdays at 9 a.m. until Sunday at 7 p.m. Father shall have parenting time if there's a fifth weekend in the month. In addition, father shall have such additional parenting time as the parties can agree. In the event that the father's work schedule changes to first shift, father shall have parenting time 5 p.m. to 8 p.m. on Wednesdays. The front of the court holiday schedule shall be adopted absent agreement of the parties to the contrary. And that is the recommendation. Mr. Smith, is this recommendation agreeable with your client, Mr. Lamming, this morning?
It is, Judge. Unfortunately, we couldn't get any additional parenting time due to the fact that he works second shift and the child is school age. So we are in agreement with the recommendation. I appreciate Ms. Brower taking the time to fully vet this. This will work, and thankfully the parties are working together to facilitate my client's time with this child. So I think that's a very good sign for the future, Judge. So yes.
Wonderful. The court would agree, Mr. Smith, and obviously the two parents should be able to communicate. And if Mr. Lamming's work schedule changes, then obviously you have additional Wednesday, and then hopefully the parties can agree that the child deserves the most time with each parent as possible. All right, Ms. Bruck, do you understand the recommendation this morning?
I do.
Do you have an objection to the court adopting this recommendation?
I do not.
All right, wonderful. Mr. Smith, you wish to voir dire Mr. Lamming? He obviously participated in discussions, but if you wish to voir dire him, the court can have him sworn.
If I could just ask him one question, Judge, you don't need to swear him in.
Okay, go ahead, Mr. Smith.
Mr. Lamming, are you agreeable to the court's entry of the order discussed at the present time?
I didn't catch all that. Something else come above you, noise-wise.
Yeah, I heard that too. Are you in agreement that the judge enter this order today?
Yes.
Very good. I have no further questions, Your Honor. Thank you.
All right. Ms. Bruck, do you have any questions for the court?
I do not.
Okay. Obviously, as circumstances change, your work schedules change, and McKenna gets older. We should always discuss modification of parenting time. Circumstances change, but the court finds this recommendation, which is agreed by the two parents, being the best interest of the minor child of McKenna. The court will currently adopt the agreement. Right, thank you, Mr. Smith, Mr. Lamming, Ms. Bruck, good job, and thank you, Ms. Brower. The court will adopt the recommendation. That will conclude this hearing. Now we can zoom out. Have a good rest of the day.
Thank you, Your Honor.
You too.
Thank you.
Have a good day. Steve, I'll call you in about 10 minutes, okay?
Sounds great.
Thank you.
Thanks.
For the record, this matter is before the court for continued pretrial conference subsequent to mediation with Mr. Walker from the front of the court. Present is Attorney Maria Zagorski representing the plaintiff, Earl Collier. Mr. Collier appears to be present with Ms. Zagorski. In addition, the House President, Attorney John DQ, representing the defendant, Tara Collier. Ms. Collier appears to be present with Mr. DQ. Good afternoon, everyone.
Good afternoon, Your Honor.
Have the parties been able to reach your own resolution this afternoon, Ms. Zagorski?
I believe so.
Is that correct, Mr. DQ?
It is, sir.
Wonderful. Who would like to place agreement on the record?
I can do that, Judge.
Please, Ms. Zagorski.
Thank you. It's my understanding that to resolve this matter, my client will sign over the title to Ms. Collier for the 2016 Ford Escape. He will bring that to my office and I will work with Mr. DQ to get it to him for Ms. Collier's benefit. My client will pay $1,500 in attorney fees to Mr. DQ within the next 6 months. Each party will keep their own property, any personal property that's in their respective possession. My client will keep the real property known as 103. Clear of any claims by Ms. Collier. She will keep 128 or any interest she has in that, and she will be entitled to any inherited property, real and personal, from her parents' estate. Spousal support will be forever barred between the parties, and neither party may petition the court at any point for any spousal support. We'll have the standard life insurance provision, and each party will keep any retirement that they have free and clear of any claim by the other party. I believe that is the party's full agreement.
We just got to add some language that says that the Dodge Dart that Tara bought with estate money while they were married remains in her name.
No objection.
That's an accurate statement.
All right, thank you, Mr. DQ. Mr. and Mrs. Collier, can you both please raise your right hand to be sworn, please? The court notes, Ms. Gorski and Mr. DQ, the proofs were taken back on July 8th. We simply have to update the proofs by virtue of testimony of Ms. Collier that she's not now pregnant. But with that, Ms. Gorski, you can proceed to confirm the agreement with Mr. Collier, please.
Thank you. Please state your name for the record.
Earl Donovan Collier.
Did you hear what I just stated to the judge regarding what I believe to be the settlement in this matter?
I did.
Did you understand it?
I did.
Do you agree with it?
Yes.
Do you understand that the judge would set this matter for a trial and take testimony and that he could decide things differently?
Yes.
Do you understand if the court accepts this agreement that that will not happen?
Yes.
Do you have any questions about the agreement?
I'm all set.
Do you believe that it's fair?
Yes.
You are not particularly happy with me or my representation, are you?
Unfortunately, I do not. I am not.
Okay. And I offered today to you the opportunity. In fact, I have an order allowing me to withdraw, correct?
Correct.
And I asked you to sign it?
Yes.
And you elected not to?
Correct.
Okay. You understand that you have an independent right to counsel?
Yes.
I urge you to retain a new attorney.
I will.
Okay. But if you retain a new attorney after today, you can't undo what we're doing.
That's fine.
You can't come back and ask the judge to do something different. If the judge accepts this agreement, it's binding upon you.
That's fine.
Are you sure you don't want to talk to somebody else?
I am sure that I want this done.
Well, okay.
So yes, I am sure.
You don't want to talk to another attorney before the court adopts this agreement?
No, thank you. Let's go with what we've got. That'll be fine. Thank you.
Okay. Thank you. That's all I have, Judge.
Mr. Collier, you indicate you want to talk to another attorney, but this is a divorce without children, so there's nothing to change. There's no spousal support, so you can't ask for reduction. We can't undo settlements as a property settlement.
I understand.
So what do you want to talk to another attorney about? I mean, there's no purpose served. I want to make sure you understand that.
You're correct. Yes, I do understand that.
You want to talk to another attorney? Now is the time before the court adopts this
I
agreement.
do not want to talk to another attorney.
Okay. You participated in the mediation, correct?
I did.
And the agreement that has been placed upon the record, have you agreed to that fully and voluntarily?
Don't interrupt the judge.
Sorry.
Is this a free and voluntary agreement on your part?
Yes, it is.
Anyone promised you anything or threatened you in any way in order to get you to come to this agreement?
No, sir.
Okay, I'm sorry, you had another comment, a question?
I just wasn't sure of the process and I'm not sure of the facts that I had gotten, but that's okay. I never wanted anything from Tara to begin with. I actually just wanted answers. I thought after the 14 years of marriage that I was at least entitled to an answer, but I know now that sometimes you don't get the answer.
Well, clerk assure Mr. Gorski is a long-term, very experienced family law practitioner. So in terms of answers, maybe an answer from your wife as to why you can't make the marriage work, that no one can provide that answer other than her. It's a no-fault divorce in Michigan. You're the plaintiff, so you're the one that filed for the divorce. So if you want answers, I mean, you think there's other assets out there that need to be valued?
Tara kept telling me to file. I actually had understood that there would be some kind of a counseling or a conversation between, but I was mistaken. And I'm totally fine with her taking her stuff, me taking my stuff. It's never been about finances for me.
Are you asking this court to enter a judgment of divorce?
Yes, sir.
Is there any chance of reconciliation?
No, sir.
Okay. Of course, still not quite sure of your hesitancy or your reluctance to enter this into this to following the recommendation of Ms. Zagorski. Is there anything else you want to say, Mr. Collier? Now's the time.
No, sir. I'm perfectly fine.
All right. Mr. DQ, do you have any questions of Mr. Collier?
I do not.
All right, questions for Ms. Collier, please. First, if you can update the proofs and confirm she's not now pregnant, and then you can confirm with her the terms of the agreement, please.
Ms. Collier, are you presently pregnant?
No, I'm not.
Okay. With that said, you heard the terms of the agreement that were put on the record by Ms. Zagorski?
I did.
You understand all those terms?
I did.
And you agree to having a judge sign a judgment of divorce that contains those terms?
Yes.
And you understand that in accepting this, you can't have a hearing anymore. But if you did have a hearing, there's a good chance that the judge would have done something that would have been better than what you're taking. He could have done something that was the same, or he could have done something which would be worse, but you still want to go forward with this.
Yes, I do.
I don't have anything further. Oh, are you okay with my representation of you?
Yes, I am.
Thank you. I don't have anything further, Your Honor.
Thank you, Mr. DQ. Ms. Zagorski, do you have any questions of Ms. Collier?
No, thank you, Judge.
One last question for you, Mr. Collier. Do you understand if the court adopts this agreement, there will be no trial or hearing on these issues?
Yes, sir.
It's just a matter of, and you give up your right to that trial, is that correct?
Yes, sir.
Right. Ms. Zagorski, you'll prepare the judgment?
I will.
Your Honor, I'm going to ask something out of the ordinary, since I'm sure Ms. Zagorski will not be representing Mr. Collier over the next 6 months. Can we set the matter for a review date in 6 months so that I can, I don't want him just taking off on me and not paying the $1,500. With Ms. Zagorski out, I won't have any ability to nicely get that money from him.
Judge, I don't have any reason to believe that my client would not comply with a court order, and a judgment is a court order. If Mr. DQ isn't paid, he knows my client's address. He can reach out, and if he needs to avail himself of this court, we can reserve jurisdiction in the judgment.
Well, certainly this court will reserve jurisdiction to enforce the terms of this judgment. So, Mr. Collier, obviously want to comply with it. If you don't pay the $1,500 as you've agreed to within that time frame, it end up costing you. It will, in fact, cost you more in the long run, because if Mr. DQ has to bring things back to court, he's going to ask for additional costs unnecessarily incurred, and the court will grant that. So you want to be prudent about this. Follow the order. You don't want to create more of an expense to the parties, particularly yourself.
Yes, sir.
So, Mr. DQ, in response to your question, I simply can't. I'm reluctant to schedule this matter for review because of the fact that the court, by implication, reserves jurisdiction to enforce the terms of the judgment.
Yes, sir.
Just notice that you can file a motion for order to show cause, and the court will award additional attorney fees if necessary. The court would like to thank Ms. Zagorski and Mr. DQ for helping facilitate a resolution, as well as, of course, Mr. Mediator Josh Walker. And the court would applaud you, Mr. and Mrs. Collier, without question. I will say without question, the best resolution is one in which you both participate as you have, as opposed to have the court throwing things up there and have the court decide these matters. Rest assured of that. You're both represented by capable family law practitioners. Your best interests were served by reaching your own agreement today. I can assure you that. Based upon the testimony that's been provided this afternoon, as well as previously, as well as the complaint filed in this case, court finds that jurisdiction has been established once again, and that there has been a breakdown of the marriage relationship. There appears to be no reasonable likelihood that the marriage can be preserved. According upon receipt of the judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from the bonds of matrimony. Ms. Gorski, you'll prepare the judgment, correct?
Yes.
Thank you both. Good luck, Mr. and Mrs. Collier. That will conclude this hearing. You can all zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you.
Welcome. For the record, this matter is before the court for the purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Ronald Bruce representing the plaintiff, Margaret Smith. Ms. Smith appears to be present. In addition, Attorney Christine Hills is present representing the defendant father, Lonnie Stump, and Mr. Stump is present. The parties have conferred this afternoon with the front of the court. The court has received a fine recommendation that father shall have parenting time every other weekend, Fridays at 5 p.m. until Tuesday at 7:15 a.m. The parties shall use AppClose to communicate only regarding issues involving the minor child. And father shall have such other parenting time as parties can agree. If a significant other is to be in the presence of the minor child, the other party shall be informed and the person's name and date of birth shall be shared. And there should be no posts on social media regarding this case or the custody of the child. That is the recommendation. Mr. Bruce, is this recommendation good with your client?
It is, Judge.
Thank you. Ms. Hills, is this recommendation good with your client?
It is, Your Honor.
Wonderful. Would you like the parties sworn if you wish to voir dire them regarding the recommendation?
Yes, please.
All right, Mr. Stump and Ms. Smith, can you both please raise your right hand to be sworn?
I do.
I did.
Thank you. Ms. Hills, you're going to be with Mr. Stump, please?
Yes, Mr. Stump, would you state your name for the record, please?
Lonnie Aaron Stump.
You've heard this agreement that's been placed on the record by the court this afternoon?
Yes.
And is that the agreement we reached in conference with Ms. LaPrade from friend of the court?
Yes, ma'am.
And you understand entering into this agreement, you are forsaking an overnight of parenting time every other week in favor of agreed upon parenting time between you and mom?
Yes, ma'am.
And you're willing to do that?
Yes.
Right? Do you have any questions about this agreement?
No.
Are you satisfied with my services?
Absolutely.
Thank you. And do you believe at this time that this agreement is in your daughter's best interest?
I do.
Thank you. Nothing further.
Thank you, Ms. Hills. Mr. Bruce, do you have any questions, Mr. Stump?
No, Judge.
Questions for Ms. Smith, please?
Ms. Smith, you also heard the agreement, correct?
Yes.
You believe it's in your child's best interest for the court to adopt that, correct?
Yes, I do.
And you're asking the court to enter that as a resolution of this matter today, right?
Yes, that's correct.
Nothing further, Judge.
Ms. Hills, do you have any questions of Ms. Smith?
I do not. Thank you.
The court would note that any other prior orders which are not inconsistent with this order will continue in full force and effect. For example, the parties will use the defendant mother's school district for the front of the court holiday schedule. That was previously ordered, so that will continue as an example. I believe that was the only other thing the court wanted to point out. In any event, the court would like to thank Mr. Pratt for her assistance, as well as, of course, Attorney Hills and Bruce for helping facilitate a resolution. The court would applaud you, Mr. Stump and Ms. Smith, for reaching your own agreement. You know what's best for your child better than anyone in this world. Be flexible with each other. Mom, if you got some issues, reach out and be a little, no reason why, if it works with your schedules, that dad can have more parenting time. This is the bare minimum. So make it good for each other and your child. All right, with that, the court finds the agreement between the best interest of my child. The court will currently adopt that agreement. All right, thank you all. That will conclude this hearing. You can all zoom out. Have the rest of the afternoon.
Thank you, Your Honor. We appreciate the courts and the parties' patience with us this afternoon as well, while Mr. Bruce and I were tied up in another court.
Not a problem, Ms. Hills.
Thank you.
For the record, this matter is before the court on plaintiff father's motion to modify parenting time and other relief. This hearing is being conducted via Zoom. Present is Attorney Kimberly Kuhn, representing the plaintiff petitioner Brooks Piggin. Mr. Piggin is present with Ms. Kuhn. In addition, Attorney Eric Langton is present, representing the defendant, Mother Mary Nee, and Ms. Nee appears to be present with Mr. Langton. Good afternoon, everyone.
Good afternoon, Your Honor.
The parties have conferred with Mr. Brown this afternoon from the front of the court, who has provided the court the following recommendation. The recommendation is that the parties shall share joint legal custody of their 15-year-old son. David Lawrence shall have no contact with the minor child. Parties shall maintain the status quo with respect to parenting time. The minor child shall be interviewed by Catherine Scott in front of the court on September 5, 2024 at 4 p.m. for a preference interview. The front of the court shall hold all child support payments pending that review hearing. The party shall complete the SMAW program. The defendant stated that she completed the program 1 year ago. Finally, the party shall appear back for this court for review on Tuesday, September 24th at 9:45 a.m. That is a recommendation. Ms. Kuhn, is this recommendation good with your client?
Yes.
Ms. Kuhn, we can't hear you.
Yes.
Oh, there it is. I'm sorry. Thank you. September 24th, 9:45. Right, Mr. Langton, is this recommendation good with your client?
Yes, Your Honor.
All right, so attorney, first of all, no contact with David Lorton. Should it simply say that the child shall not be in the presence of David Lorton? I mean, I know maybe there's no difference. So in other words, David Lorton is a stepfather, correct?
That is correct, Judge.
Okay.
And Your Honor, I did want to inquire, is the PPO matter in front of this court as well, or was it issued by a different judge?
I do not know. I thought someone, I do not have a file up here. I do not know. Perhaps the parties can answer that.
I can, Your Honor. It was issued by Judge Lohmeyer on May 6th of 2024, and there is currently a domestic violence second charge. There's a warrant against Mr. Lorton, and the victim is the minor child, Mario.
Okay.
And Judge, is it typical to get, given that both of these matters involve the minor child, is it typical to get that PPO file transferred to this court?
Absolutely. And actually, I'm surprised it was not, because the PPO, the person who handles PPOs, always assigns it to the judge if there's a pending case. And this DC case has been assigned to me from day one. So I'm not sure why, unless, and the only time to go to another judge is if I was out of the jurisdiction, and that judge would sign it in this court's absence, but I was certainly available in May. I'm not sure. Was that a late Friday afternoon in May?
Judge, is there something that we would need to do to get it transferred to this court, or is that just a matter of someone?
We can, Mrs. Brower can put in this order that if you have the PPO number, that PPO is reassigned to this court. I think that would do it.
I do not have the PPO, the file number handy. I'm sure actually, I think it's in Ms. Kuhn's motion.
I can get that number.
I believe it's, yeah.
Why I was assigned to Judge Lohmeyer, that's obviously a mistake in the clerk's office. It should have been assigned here. So yes, we could put in this order that PPO is reassigned to this court. And I think that would take care of it. So we'd have the file up here. Next time we come back for that review, Mr. Langton, the court would have that file in front of it.
Okay, sounds good, Judge.
So presumably that PPO says no contact. Is that correct? So this simply reiterates that same condition?
Judge, I do not have a copy of the PPO. I just have a copy of the factual allegations. So okay. I would assume, I mean, every single PPO I've ever read has that no contact provision in it. So
Your Honor, it looks like entering onto property where petitioner lives, entering onto property at Willie Road, assaulting, attacking, beating, molesting, or wounding Mario. It's ordered that he's not allowed to follow petitioner, appear at petitioner's workplace or residence, contact petitioner by phone, send mail or other communications, or confront petitioner in a public place or on private property, threaten to kill or physically injure. It looks like E, F, G, H, J on the second page are checked, and then A, B, C on the first page are checked. So
on the first page is prohibited contact.
Prohibited, yes.
Okay.
Yep. Yep.
All right, so that reiterates that. We'll get the file up here for our next review. Other question, the court had the status quo regarding parenting time. The court's understanding, maybe I've missed something, that father's parenting time was suspended by virtue of a February 2016 order, but the parties he still practiced parenting time. Is there an order that permits parenting time or reinstates parenting time for dad?
No, Your Honor. Since that order suspending, it appears that the parties didn't follow that order up until June of 2023, and my client was exercising reasonable and liberal parenting time no less than every other weekend. So with that order, he was still exercising parenting time, but in June of 2023, the child came to live primarily with my client. So my client has had Mario since June of 2023. So for a year and 2 months, he's been primarily with dad, exercising parenting time with mom on alternating weekends, but a lot of weekends were not exercised. So he's been living with my client, going to school in my client's school district. Again, that's since June of 2023? Correct. For now, when did what month was the PPO entered? The allegation says the 2024. What month was that PPO entered? Your Honor, it's dated May 6th of 2024. I'm looking at it right now. Thank you. So I want to make sure I understand the status quo. The status quo is that Mario goes to his mother's home on alternating weekends? No, he hasn't been going to his mother's home. No. The abuse occurred in mother's home. Mother married Mr. Lorton. They lived together. The abuse actually occurred in the home. He's not been going to the home since. He's actually in counseling right now. It was pretty bad. So he's not been to mom's home. I think that mom has maybe taken him out to dinner, has gotten together with him. dinners and things like that, but not much, unfortunately.
So it sounds like there's not really any status quo with the parenting time. Should it just be parenting time as agreed?
I think that's fine as well. I mean, well, also, there hasn't been any communication between Mr. Piggin and my client whatsoever, so I don't know that they can agree on parenting time. They're not agreeable to co-parenting counseling. So I don't think that we can set it up to where they agree with each other to have parenting time. The status quo, Judge, essentially just means my client reaches out to Mario often, Mario reaches out to her often, and they just meet up whenever they want to see each other. Outside of the presence of Mr. Horton, since the PPO has been issued.
Okay, all right. If everyone's comfortable with that language, that's fine.
We are. And there was one instance where Mario was actually in a car and Mr. Lorton was there, but not in the car. And, I would ask that Mr. Lorton not be anywhere, especially in light of the fact that there are some criminal charges pending and child's terrified of him.
Well, all right. The court's inclined to adopt the recommendation with the addition that the personal protection order be reassigned to this court. So we'll have the file up here when we come back for the review on September 24th at 9:45 a.m. Ms. Cooner, Mr. Langton, do you want to voir dire your respective clients? Obviously, they participate in the discussions with Ms. Brower this afternoon.
I don't need to, Judge, but thank you.
One moment, Judge. Judge, I do not need to voir dire. The only addition that my client wishes to state is that she does hope that co-parenting counseling can happen at some point. She does think that it would be good for the both of them. But obviously, that's not the recommendation at this point in time from friend of the court.
No, Your Honor, we have a 15-year-old and really the parties have joint legal custody. So getting information from the school and counselor is something that they're both going to be able to do. My client's going to obviously let mom know when there are counseling appointments and things like that. But I don't really feel that there's a need at this point for communication counseling. We don't have a small child. So I think that if they can communicate pertinent information back and forth regarding Mario, that's all they really need to do. And I don't think that there's going to be an issue with that at all. So.
All right. Thank you, Ms. Kuhn. Is Mr. Piggin inform Ms. Nee of the name of the counselor and the agency?
Yeah. It's a counselor that Ms. Nee had chosen. So it's the same counselor. So there's been nothing done that neither party knows nothing about. I mean, the school, selection of, Mario going to my client's, school in the school district, that was done joint. So they do communicate well enough. To have a kumbaya and use communication counseling to become best friends, it doesn't make any sense to me. It's really going to be situation where they know how to communicate and they just need to communicate information pertaining to Mario that one of them gets that the other one wouldn't have access to, like appointments and things like that. So my client's fine with that. And he said he's, open to, texting, calling. So there's no issue.
Okay. Any objection to this court adding a sentence in the order that counseling for Mario shall continue?
No, it can, absolutely continue. I just don't want anything in the order that would somehow not permit insurance to cover it. Right. I don't think either party has any notion of pulling the child out of counseling. He needs that.
All right, thank you. Under the parenting time paragraph, Ms. Barber, you can simply add that counseling for Mario will continue. Ms. Nee, the court suggests reach out to that counselor and make one with that counselor in terms of any suggestions that counselor may have for you to reestablish a relationship with your son. So we want to continue that counseling so we can get back in that and develop that relationship. Right, with that addition, two additions to that addition, that continue counseling and the PPO be reassigned to this court. That should conclude everything. Is there anything further, Ms. Kuhn or Mr. Langton?
No.
Sorry, Judge, what was that?
Anything further?
No, Your Honor.
Okay, right. Court will adopt the recommendation. We'll see one back here September 24th at 9:45. And will this interview with Ms. Scott, will this be a personal interview with Mario, Ms. Brower, as opposed to over the phone?
It will be an in-person interview, yes.
Thank you. I think that's appropriate. All right. Okay, now we'll conclude this hearing. Everyone can zoom out and have the rest of the afternoon. We'll see everyone back on September 24th then.
Thank you, Judge.
Oh, you're welcome. Someone from the clerk's office, do you want to copy this order? You want copies of order so you can take down to Bobby and have the PPO reassigned here?
Yeah.
All right. I'm just surprised why it was assigned to her in the first place, unless I was out of town. But that's usually May, whatever. But
Here, I have
usually,
the 2:30.
maybe ask Bobby if she has any idea why it was reassigned. Maybe just an accident. Because usually it'd be my case, but another judge. No, they're assigned if they first look to see if there's an open case. I get the majority because I have a majority of the family court cases. A lot of PPOs are in family court cases. So maybe just ask her. I'm curious.
Hello? Hello, can you hear me?
Yes, we can hear you. One moment, please.
Okay.
For the record, this matter is before the court for the purpose of reviewing records from the defendant's father's physician, I believe regarding a psychological mental health evaluation. This hearing is being conducted via Zoom. President Attorney Alex Goldman, representing plaintiff mother Sarah Perkins. Ms. Perkins is present, as is the defendant father James Wentworth. Good afternoon, everyone.
Good afternoon, Your Honor.
I don't know if Ms. Soprano at the front of the court or Mr. Goldman, if you received his copy of any mental health evaluation. The court has not.
Your Honor, I did have an assessment that was scanned into the on-base file. Mr. Goldman received that while we were in court with Mr. Wentworth's permission. Mr. Wentworth directed me that it was sent, so I did not send it to the court.
Okay, that's fine, as long as you have reviewed it, Mr. Pratt. Right, and you received a copy of that assessment, right? Correct, Mr. Goldman?
From Ms. LaPrade, yes.
All right, the recommendation of Mr. Pratt is to reinstate parenting time for the defendant father, Mr. Wentworth. Parenting time will be with my child at his home with the paternal grandfather present every Sunday from noon until 4 p.m. Parties shall meet at the Milan Police Station. And it's further on, Mr. Wentworth completed the mental health assessment virtually. That's
Yes,
the recommendation.
yes. I did apologize for the timely fashion. I could evaluation, and I do appreciate the court's patience.
Okay. All right, so Mr. Goldman, does your client agree with this recommendation?
No, Your Honor.
Okay. I'll let you, Mr. Wentworth, do you agree with this recommendation?
Yes, Your Honor. I do feel that, I mean, every child should have both of their parents actively involved in their life. And this situation is something that'll never happen again. And moving forward, I think it's only best that me and Sarah do everything we can for this child. And any parenting time that I can get, I know it's just steps in a better direction. So from noon until 4 p.m. every Sunday would reintroduce my son's father back into his life, which I feel is important.
Well, it's important that you continue your mental health treatment, taking recommended to prescribe medications.
Yes, Your Honor. And I do believe the courts have received a letter from a counselor that did, I mean, just to reassure you that I am trying my best to show you that I am stable and I am able to provide Colton with a healthy and comfortable environment to grow up in. You know, I think every child should have that.
And obviously, we want the child to be safe when the child is with you. And we don't want to scare the child by any inappropriate or unusual actions, conduct on your part.
Of course, Your Honor. And I apologize for this entire misunderstanding. I think there's a lot of conflicting views as of right now, but I just want to show the courts that I am perfectly capable of raising my son in a safe and healthy environment.
Do you live with your grandfather?
Yes, I do. So he'll be here all the time. I have a lot of family around here, and I'm sure none of us have seen Colton in 4 months. So he's going to get a lot of visitors from all of my family.
You continue to engage in regular counseling?
I can do that, yes, if you would like.
I'm not saying do you intend to. Are you currently involved in regular follow-up counseling?
Yes. Once again, it's all done virtually. I did a session back when this first started, just trying to get steps in the right direction to providing the mental health evaluation. But if it would look better to the court that I see this therapist once a week, I can provide that.
When is your next appointment scheduled?
I could call her after this hearing and see when her next available time would be.
Are you currently taking any prescribed medications?
I am not taking any medications.
All right. No medication is being recommended, is that correct?
Yeah, I mean, I take Tylenol when I have a headache, but as far as carrying out my everyday functions, I don't need psychological any kind of a psych med. I'm perfectly capable of functioning just the way I am. And if I wasn't, I'm sure the psychologist would have prescribed something.
Okay. All right. So thank you, Mr. Going back to you. What's the basis for your client's objection if it's we have to be supervised by the paternal grandfather?
We don't think that there's been any evidence provided that shows that Mr. Wentworth will not traumatize his child further. We have this assessment where he basically told somebody over Zoom, I'm fine. The whole thing back in May was a misunderstanding. And the therapist said, oh, sure, he seems fine now. I don't doubt that Mr. Wentworth has periods of lucidity and stability. The problem is we need to make sure that it's never going to happen around his child again. The fact that he didn't automatically schedule regular therapy sessions and that no mental health medication is needed. The allegations in the motion speak for themselves. We'll have verification of those facts once we get the police report back, which is taking longer than I'd expected. They have until October 15th. The child is now in therapy. The therapist recognized that the child has been traumatized by this incident, a severe incident. Remember, Mr. Wentworth was naked with his child, ranting about radiation and planes falling from the sky. This wasn't some misunderstanding. He appears to have misreported the nature of his hospitalization to the psychiatrist or psychologist performing this assessment. He said that he was involuntarily committed for 10 days because Mrs. Campbell alleged that he was suicidal. That's grossly mischaracterizing why he was institutionalized for 10 days. We don't have any paperwork from that from Havenwick Hospital where he was institutionalized. We don't have any police reports verifying that what my client said is true. We don't have any indication that a mental health provider was given the full picture. I think that anybody who would read the motion would want to follow up and at least ask Mr. Wentworth some directed questions. But it appears that he just sat before somebody, said, I'm fine. And Mr. Wentworth does seem fine today. The problem is we really need to be 100% sure before we put him in the same room as a child. The court's own order states that he has suspended parenting time, not restricted, suspended parenting time until we have a mental health physician provide testimony to this court. I just think it's premature to put him in the same room as the child, Your Honor.
Well, that's
so
why
the report you received is not adequate, in your opinion, then, Mr. Goldman?
Correct.
Your Honor, if I may.
Okay, just a minute, Mr. Wentworth. Yes, the allegations are quite disturbing. Mr. Goldman, do you intend, and I realize you're new in the case after Mr. Keeney has left your office, and have you issued any subpoenas to the Trinity Health Behavioral Services Facility where Mr. Wentworth was institutionalized for what, 7 days or something, 10 days? Do you have those reports, police reports, medical reports? I mean, that would certainly provide, of course, some insight.
Certainly. Like I said, police records are forthcoming. The Michigan State Police told us that they have until October 15th to comply with our request. As far as subpoenaing the mental health records, I can get on that right away. Mr. Wentworth says that he has those in his possession. I certainly, if there was a way to allay my concerns, we are willing to be reasonable on this. I just think it's premature to take Mr. Wentworth for his word.
Well, with that being said, I'm sure if the psychologist, who is a medical professional that did conduct my evaluation, had any concerns, they would have put that in the summary. But I have received
Mr. Wentworth,
yes.
Did you inform your counselor, the person that did the evaluation, that you were institutionalized for 7
yes,
or 10 days?
I've explained them the entire situation.
Well, he lied about the situation.
Did you provide them a copy of all the records?
Yes, I have. I do have physical copies of those, and I have no problem submitting those to Mr. Goldman. But that doesn't change the fact that I'm still here because I want to be the best father that I can be for my son. And I do believe he is entitled to that. And that's why we have
Mr. Wentworth.
Yes.
We understand that, but obviously these allegations are pretty significant, pretty disturbing. And again, the
Well,
question is, did your counselor or the person who wrote this letter, were they aware of these allegations?
Yes, they were.
Have they looked at the reports from Trinity, from St. Joe's Trinity Health Behavioral Services? Do they have all those reports?
Yes, I've submitted all the documents that I have. And I think if Child Protective Services had any more concerns, they wouldn't have dismissed the allegations, which I understand the severity of this. but I just want the courts to know that I am capable of providing my son with a safe and healthy environment. And the events that took place in the past, I mean, it can't be changed. There's a lot of conflicting views on it, but I can assure the courts that he will be in a safe and comfortable environment, and he will be supervised by my family members for this little bit of time that I get him on Sunday. I mean, it's not like it's going back to my normal custody, which was almost every weekend. I can understand Mr. Goldman's perspective on this, but I can assure you that Colton was never in any danger. He will never be in any danger because I wouldn't put my son in harm's way.
Well, but I'm sure that he was very frightened by your conduct, Mr. Wentworth. So
neither of us
Mr.
could
Goldman,
expect my dog to jump out of the car either.
Mr. Goldman, does the letter that you received, does that person acknowledge review of the reports from St. Joe's Behavioral Services?
No, the entire assessment begins with James reported. So there were no records reviewed whatsoever by this person performing the assessment. I see Ms. LaPrade here, so I don't know if she wants to chime in.
I'm just here in case Judge has questions.
So, Your Honor, my concern is that Mr. Wentworth is self-reporting a version of events that dramatically minimizes things. Just now, he started to say, the dog jumped out the car. That's all we were doing is looking for a missing dog. He mentions nothing about being naked and rambling about radiation and planes falling from the sky. I think we all recognize that's pretty clearly a psychotic episode that would require more than a doctor saying, yeah, you're fine. No follow-up needed.
I don't mean to interrupt, but how would I be exposed to radiation? I mean, I don't work at a nuclear power plant, and in the state police assessment, I'm sure they will describe that I wasn't naked at all. I was simply walking down the side of the road. I wasn't naked.
Mr. Goldman, what information did your office have to support these allegations in the petition?
Ms. Campbell's word. I can also have her grandfather, who was there on that day and helped discover. He can come in to testify.
All right. The court is not comfortable this time, Mr. Wentworth. We need something that from your counselor says that that person has reviewed all the records from.
That's the Trinity Health that you're referring to. That's my primary physician. They did review all of the documents that Havenwick Hospital gave me, and that's what they wrote in that summary that was submitted to the courts. But the last time we were here, you made it very clear to me that that was not a mental health evaluation, which I did in fact submit. The friend of the court has received it. I've given you everything that you have asked me, Your Honor. And I understand the concern that you have, but I can assure you that this little boy is in a safe home here. And even just for 4 hours on Sunday, I can show you that he will be in a safe and comfortable environment, and it will be supervised to alleviate any concern.
Well, the court's concern is that the counselor's recommendation letter is all about self-reporting. We need something more. I want to make sure that counselor has the full picture. So
that was
Mr. Goldman, we either need to get the grandfather, the grandfather, take testimony from him, in terms of supporting these allegations, if it's just based upon mother's word. And Mr. Wentworth, we need something more, that person has reviewed the records from late May, from May 28th, when you were hospitalized at St. Joe's. And that reviewed those reports.
My primary physician has, and that's the Trinity Health that you're referring to, that was written by my primary physician, who did take into consideration all of the events that took place that day that led to me being hospitalized. And I also informed the psychologist of all of this, the professional that did my mental health evaluation, which, to my understanding, mental health evaluations are conducted in a very specific manner. So I just did the way that they did it. I don't really know what more I can give you. I've received the mental health evaluation that you requested. It cost me almost $400 to insure you.
Understood, Mr. Roth, but it sounds like it's all based upon your self-reporting. They didn't do any background examination of records. It's all based upon what you told them. Today, you sound very good. Tomorrow, maybe a different story.
And I can assure you, Your Honor, that I've been stable this entire time. And what we're boiling down to now is a matter of what Sarah's saying against what I'm saying. And I don't want that to be the reason Colton doesn't get to have his father. You know, we could sit and argue all day about this and that, but at the end of the day, I'm just trying to be the best father I can be to my son. And I feel he deserves that, even for 4 hours on a Sunday.
All right, it is limited right now, Mr. Goldman, and the court's concerned about the time delay associated with separating dad or any parent from a child. So at this time, the court's going to adopt the recommendation that dad has parenting time at the home of the paternal grandfather Sunday from noon to 4 starting this Sunday. But the court's going to review this, and the court will, if necessary, will modify it. Number one, Mr. Wentworth, you need to get the court's not comfortable with the letter you have obtained. It's got to be something other than simply self-reporting. Mr. Goldman, if you want to come back, provide, you can subpoena the grandfather in terms of document what happened, and also get a police report and reports from the St. Joe's Behavioral Center. Will you sign a release, Mr. Wentworth? That would make things a lot quicker if you will sign a release for Mr. Goldman.
Well, apparently Mr. Keeney is no longer in the office, so I don't have any of Mr. Goldman's information at all.
Okay, Mr. Goldman is in the same office. He's representing the mother. Will you sign a release so we can get all the medical records at St. Joe's?
That's fine. And I have all the documents that he could ever need that I will turn in first thing Monday morning, and I'll sit down and talk to him about everything.
Do that, and that will provide some insight for Mr. Goldman and the court. But we'll try this parenting time. Make sure your grandfather's there. It's just 4 hours. Mr. Goldman and the court, at least with some comfort zone knowing that the grandfather will be there.
So that will begin this Sunday, you said?
Well, now getting me the Milan Police Department. How is mom going to know his grandfather's at the home?
Well, I mean, he lives here, so do I.
I understand, but we don't know
I'm fine with her coming here and seeing him. If she'd like to be present for some of that, that's fine with me too.
She wants to make sure her grandfather's there. Mr. Goldman, what about if is your client willing to drop off the child at the home of the paternal grandfather and make sure the grandfather's there?
Before we get that, Your Honor, can I say some more in support of our position?
I'm sorry, you want to?
That's to reconsider. Your
I'm
Honor.
sorry?
I'm asking you to reconsider before your order becomes final today.
Well,
I'd like to say a couple things additional.
Okay, go ahead. I don't know what else you want to add, Mr. Goldman. Go ahead.
The child just recently got in to see a behavioral therapist, and those therapists will testify that the child has been traumatized by spending time with father. I think that would put the child's health at risk by prematurely putting him in contact with Mr. Wentworth.
I think he's being more traumatized by not being able to.
Hold on, Mr. Wentworth. Don't interrupt. Mr. Goldman, do you have a report to that effect?
Not today, Your Honor.
So we were just reporting what Ms. Campbell is reporting to you. So everyone's reporting something else. So we'll give you a quick review date. If you want to get a letter, then the court can, well, okay. Well, I'll tell you what, we're going to adjourn this matter. I'm going to be in the safe caution, but Mr. Goldman, you need to come back with documentation. We're not going to drag us out for 6 weeks. So you need to, if necessary, Mr. Wentworth, get the documents to Mr. Goldman's office. Mr. Goldman, get those subpoenas out today. And so the court will continue the ex parte order. The parenting time, we're going to hold off till we get more information. We're going to err on the side of caution. And you need a particular letter from the child's counselor.
Your Honor, that's
just not going to take whatever Ms. Campbell is telling you.
Your Honor, that's concerning. Colton has got a family here. He has supervision. I don't know how much more I could give you. Just this little bit of time from noon until 4 on Sunday. Please just let me be my son's father for that bit of time. And in the process, we can submit whatever documents need to be submitted.
The court will not permit parenting time until we come back, and I'm going to give you a time. And Mr. Wentworth, provide as much information you can to Mr. Goldman so that we can reestablish parenting time when we come back.
Well, we have a hearing for the 5th of September. We have a hearing at
1:30.
Your Honor. Sorry, Your Honor. What was that date?
September 25 at 1:30.
Thank you, Your Honor.
That's good for me.
Right. So, Mr. Goldman, get some documentation together, because if we don't have documentation, I'm inclined to permit parenting time when we come back September 25.
Understood.
So
Your Honor.
Reports from, yes, Mr. Brad.
Mr. Wentworth filed a parenting time motion that's scheduled to be heard before referee Homrich on September 5th at 2 p.m. I think that that should, in the fact that all this is being handled by your court, that needs to be vacated.
Yes, that'll be vacated. So, Mr. Wentworth, that hearing before the referee will be vacated. Everything's come to this court. We'll get much quicker relief, because even if the referee recommends parenting time, it's subject to a 21-day objection period. So that hearing before referee Homrich, September 5, that's being canceled, vacated. You're going to come back to this court September 25th at 1:30.
So you're saying I have to, Colton doesn't, I just don't understand why this is all for Colton's best interest, but Sarah and her attorney don't have the proper documentation to show that I don't know how much more I can give you.
Mr. Wentworth, you don't have the proper documentation either. I want something from a counselor that says that they reviewed those assessment records from St. Joe's Behavioral Center when you're admitted, and they know all the background allegations and facts, and rather than just self-reporting what you told them. Ms. Campbell self-reporting too, so I don't know what to believe. We're going to err on the side of caution to protect Colton, so we need documentation when you come back here. So the court suggests go back to your counselor saying, here's all of my records. Then he can put in his letter, I reviewed the following documentation Mr. Wentworth provided me. I'm aware of the concerns, the allegations, and if you were in St. Joe's for, 8 days? I mean, there obviously must have been some concern. You were just evaluated at least, Mr. Wentworth. So follow up with that counselor, have the counselor revise their report to the court. And Mr.
Well, the psychologist that did my mental health evaluation. Can I please, Your Honor? I just want this to be
again-
clear. You don't have to do this again. Do you need documentation from a licensed psychologist or a therapist?
Well, I don't know who did this letter.
Well, I have a letter to you from my primary physician, from a psychologist, and from a therapist. So I've given you all three of those. Which one do you need?
Well, I prefer the psychiatrist, but that psychiatrist should say, I've reviewed the following documents. I've reviewed the reports from St. Joe's Behavioral Center on May 28th, 2024. And I'm aware of the incident involving Mr. Wentworth back in that date that caused him to be committed to that facility. That they got the history on it. Not just what you're reporting. They need to rely upon documentation.
Yes, that was the psychologist that conducted my mental health evaluation. To my understanding,
it's all self-reporting, Mr. I'm not going to keep repeating myself. It's Wentworth. My understanding, it says it's based on what you reported. He needs to see documentation rather than what you're telling him.
So from my doctor,
parenting time will continue to be suspended until we come back to court September 25 at 1:30.
Your Honor, brief question. Will you permit testimony at that hearing?
With about like 10 minutes. So if you want to bring grandfather, and rather than get a third party in terms of what he observed, if you want to subpoena Mr. Wentworth's grandfather, then the court brings a very brief testimony.
Please do. Subpoena everybody that you want, please.
Thank you, Your Honor.
I'm sorry. Any other questions, Mr. Wentworth?
No.
It's provide the documentation. The court wants nothing more than to reestablish a relationship between you and Colton, but based on everything I'm hearing, the court's going to err on the side of caution right now, just for another 30 days.
I'm going to give you everything I got, and hopefully that's enough next time.
Have your psychiatrist revise his letter to say that he's reviewed the following documentation. Give him all the documentation. Say he's got a reference in his letter.
That's what the Trinity Health, the summary from there is, but I'm going to do it again.
Okay. Okay. All right. We'll see you back on September 25th at 1:30 then.
Thank you, Your Honor.
Your Honor, that
concludes
the updated recommendation is in your queue.
Thank you. Okay.
Calling the matter of Sarah Perkins versus James Wentworth.
For the record, this matter is before the court for the purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Alex Goldman, representing plaintiff mother Sarah Perkins. Are you Sarah Perkins?
I'm Sarah Campbell.
Formerly known as Perkins?
Yes.
The plaintiff is present, and in addition, Attorney Russell Smith is present, representing defendant father James Wentworth, and Mr. Wentworth is present with Mr. Smith. Good afternoon, everyone.
Good afternoon.
Good afternoon, Judge.
The parties have conferred with the front of the court, who has provided the court the following recommendation: that father shall have supervised parenting time or visitation at family counseling shelter services. Circuit court funds shall pay for the intakes for both parties, and the parties shall split the cost of the sessions 50-50. Further, that defendant shall secure an assessment from psychologist Dr. Zubin Mystery. The parties will appear back before the court to review parenting time for dad on Wednesday, November 6th at 11 a.m. via Zoom. That is the recommendation. Mr. Goldman, is this recommendation agreeable with your client?
Yes, Your Honor.
Right. Mr. Smith, is this recommendation agreeable with your client this afternoon?
Mr. Wentworth, are you willing to go with this recommendation at this time?
Yes.
Yes, Judge. Thank you.
All right. Do you want to voir dire your respective clients on the record? They both participate in the discussions, but if you wish to voir dire your clients, I can have them sworn. Mr. Goldman, Mr. Smith?
I don't feel the need to, Your Honor.
No, Judge. Thank you very much.
All right. So both parties should contact Family Counseling Shelter Services today. You got the phone number. It's in the order here. It's 241-0180. Call them today to schedule those intakes. The sooner we get the intakes going, the sooner we can schedule this. And they do have a wait list, as far as I know.
Your Honor, they do not have a wait list as of today.
Oh, wonderful. That's great news. First time in months they've not had a wait list. So that's good. So we'll get that going as soon as possible. And Mr. Smith, do you have any contact information for Dr. Mystery?
Yes, Judge. I've already contacted him and indicated that he might need to examine my client. So I will recontact him. We will get that done as soon as possible.
All right. All right. Very good. The court appreciates, I'd like to thank Ms. Brown for her assistance as well as counsel. The court will adopt the recommendation. We'll see everyone back on November 6th at 11 a.m. Now we'll conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you, Judge.
Welcome.
Father to have a psychological evaluation with Dr. Mystery?
Correct.
Okay, very good.
Well, it says actually an assessment, but he's a psychologist. So it's basically a psych eval.
Dr. Mistry.
MISTRY.
MISTRY, right, correct? Yes.
Correct.
Gotcha. You want to call the two?